Hello guys, welcome to our new page Lawyers Corner. This page is created for spreading legal awareness in our society. For any kind of legal assistance, feel free to send us email. Those who are new, please subscribe, follow our page. Let's start. Today we will discuss about one of the famous Supreme Court case, which is Barasat Eye Hospital and others versus Kaustabh Mondal, which is very much important for those who are litigating advocate in civil area. This case is mainly based on preemption rights of the adjacent landowner. So for this we have to know first what is preemption. Preemption means the purchase of goods or shares by one person or party before the opportunity is offered to others. Thus, a preemption right is a right of existing shareholders in a corporation to purchase newly issued stock before it is offered to others. The right is meant to protect current shareholders from dilution in value or control. Preemption right, if recognized, are usually set forth in the corporate charter. Under Section 6, Subsection 1, Clause 2, preemption right has been enumerated under the Transfer of Property Act. Even the preemption right has been recognized in so many acts and legislature in India. Now, let's discuss the obiter dictum part of the famous Supreme Court judgment in Barasat Eye Hospital versus Kaustabh Mondal. This judgment was given by the Honorable Justice S.K. Kaul. It was clearly mentioned here that the right of preemption is a secondary right, and that too in the context of the right being a very weak right. It was further observed that such a right can be defeated by all legitimate methods, such as a venire allowing the claimant of a superior or equal right to be substituted in its place. This is not a right where equitable consideration would gain ground. In the second aspect of importance is that given the aforesaid position, even the time period for making the deposit, thus, it was firmly stated that the prerequisite to even endeavor to exercise this weak right is the deposit of the amount of sale consideration and the 10% levy on that consideration. Otherwise, the right will not be exercisable. Actually, in daily practice, why the case is so much important? Actually, in daily practice, what we seen that most of the preemption cases are filed to vitiate or delayed the matter. Most of the time it was previously filed by depositing only 10 to 15% of the consideration amount. So there was an undertake that the rest amount will be deposited at the time of decree. But in this judgment, Supreme Court clearly stated that either if you deposit the entire consideration amount plus 10% of that amount and file a preemption case, or do not file it. Actually, the main motto is that preemption is so much weaker right. It is not an absolute right. By this right, you are coming before the court with a prayer that your adjacent landowner should ask you to purchase the said land before selling it to another one. So, if you don't have the equal amount of consideration money upon which the sale is done, then you should not vitiate or delay the conveyance or the transfer. So, Supreme Court ordered in this case that for filing a preemption case against an immovable property, one have to file the case upon the entire consideration value of the sale deed plus 10% in addition. And after this judgment, most of the preemption case was withdrawn or the excess amount has been deposited by the litigator. So that is why this case is very much important for civil litigator or those practicing advocate who are practicing in the civil side, because after this case the entire procedure or entire conception of preemption right against an immovable property was changed. This was my view upon this case. Don't forget to share your views upon the right to preemption against immovable property.